began in 2000 with the appointment of the Commission, the Constitution of Kenya Review Commission, of which my brother Isaac Lenaola was a commissioner. That commission worked on a draft bill that was subject matter to the Constitutional Conference at Bomas of Kenya. Your Excellency, you will recall that in 2003, you were a member of the Parliamentary Select Committee on the Constitution. I believe that is where you and I first made acquaintance. And as members of Parliament, we were both delegates at the Bomas Conference, which adopted the CKRC draft bill in 2004. It is the CKRC draft that first made provision for Supreme Court. Similar provisions were contained in the document that went to referendum in 2005, but failed to meet the required threshold and was rejected. Kenya then went into the 2007 election without a popularly adopted constitutional framework, and as a result, in part, the election of 2007 precipitated a political crisis as never been seen before. As part of the resolution of the peace process that followed, the Committee of Experts on Constitutional Review, of which I was a member, was appointed to harmonize all the previous bills and drafts and to seek the views of Kenyans on contentious issues. And as a result, the Constitution of Kenya 2010 was adopted by Kenyans through referendum. This Supreme Court was birthed by that Constitution, born out of the people's vision for an apex court that would stand as the ultimate guardian of the Constitution and as an impartial arbiter for the nation's most difficult legal challenges. The Constitution gives the court original jurisdiction relating to any challenge of a presidential election result, an advisory opinion to be given to government, an appeal from a judge that has been removed from office, and any challenge on the validity of the declaration of a state of emergency. Of these four original jurisdictions, Your Excellency, the only one we have never invoked is the one relating to a state of emergency. In addition, the court is bestowed with appellate jurisdiction to hear any appeals on the interpretation and application of the Constitution, and also in the instance where an appeal is a matter of general public importance. The inaugural bench of 7 judges of the Supreme Court were appointed in June 2011. I was one of them. 2 others, Justice Mohammed Ibrahim, Justice Smoking Wanjala, are also still in office. We were later joined in order of appointment date by DCJ Rawal, CJ Maraga, DCJ Mwilu, Justice Lenaola, CJ Kome, and Justice Ouko. At this time, CJ Mutunga, DCJ Baraza, DCJ Rawal, Justice Philip Tunoi, Justice J.B. Ojwang have since retired. But going back to that inaugural bench, there were many challenges setting up a new court. When we first came here to report on duty, we found, as a totally new court, there were no offices for us to sit in, other than that of the Chief Justice, because even the Deputy Chief Justice was new. So we sat here and had a cup of tea in the CJ's office, and then we were asked to go home to wait until we were allocated temporary offices, a skeleton staff, and a courtroom. We had no rules of procedure, we had no practice directions, but there were already matters filed before us to get to work. And that we did. Over the last 12, now actually 13 years, the court has stood firm in its mandate, consistently asserting the principles of constitutional supremacy, sovereignty of the people of Kenya, and judicial independence. Challenges still, however, remain with regard to the principle of separation of powers, which guarantees judicial independence, particularly with regard to funding the judiciary as an equal arm of government, the attacks on judicial officers, and refusal to obey court orders. There is need, therefore, for checks and balances between the 3 arms of government without overreach or interference. Comity of the 3 arms of government is a cornerstone of our Constitution. Mutual respect is a necessary condition for the coexistence of the executive, legislature, and the judiciary, all who have one clear calling to serve the citizens of this great nation. Through landmark decisions, advisory opinions in moments of national impasse, and precedents, we have strengthened our democratic foundation, and I believe the Supreme Court has continually sought to ensure that justice prevails for all Kenyans. This conference offers an invaluable opportunity to reflect deeply on the court's journey and to consider its impact and future direction of its jurisprudence. We will examine the paths paved by our decisions on critical issues, including presidential election disputes, constitutional questions, human rights, devolution, and so much more. The range of conference activities include public lectures, panel discussions, moot courts, interactive exhibitions, and stakeholder engagements, where we seek to enrich understanding and encourage dialogue about the future of the Supreme Court. As we embark on this conference, may our discussions be rich and enlightening. May they inspire fresh perspectives and reinforce our shared resolve in upholding the values enshrined in our Constitution. I thank you all and welcome you all once again to the Supreme Court at 12 conference. Allow me at this time to welcome to the platform the Honorable Musalia Mudavadi, Prime Cabinet Secretary, Ministry of Foreign and Diaspora Affairs, and the Acting Cabinet Secretary, Ministry of Interior, National Administration, His Excellency, Honorable Musalia Mudavadi. Welcome.
Your Excellency, the President of the Republic of Kenya, Honorable William Samoei Ruto, Your Excellency, the Deputy President, Professor Kithure Kindiki, the Honorable Chief Justice Martha Koome, esteemed judges present, and our Chief Justices Emeritus, Professor Willy Mutunga and Justice Maraga, distinguished participants, guests, colleagues, ladies and gentlemen. When you have a privilege to speak to such an audience, you don't want to have anything that is off record. So I just thought I should make some very formal remarks. Since its establishment in 2010, the Supreme Court has been the final arbiter on issues of justice that go to the heart of our national conscience. The matters you discuss here today, from the traditions of apex courts to the nuanced balance of judicial independence and accountability, are central not only to your mandate, but to the very core of our democratic system. The Supreme Court is more than the apex court. It is the conscience of our Constitution. The Constitution of Kenya guarantees the independence of our three arms of government. Yet, while we are independent, we are not isolated. We are distinct, yet we are part of the same fabric that is Kenya. Our citizens do not separate us into the judiciary, executive, and legislature. They see only one government. And the expectation is for a government that works as a unified body to serve their interests, their needs, and their aspirations. Ladies and gentlemen, while the arms of government are independent, we serve the same citizens and the same republic, and as such, inevitably, all arms are interdependent. I urge each of us gathered here within the judiciary, the executive, and the legislature to champion this spirit of interdependence in our approach to public service. As members of the judiciary, I also urge you to continue taking a firm stance against corruption. The Supreme Court has the power to set precedents and to reinforce the standards of integrity and fairness that echo through all sectors of our government. I appeal to all of us in public service to be beacons of honesty and transparency that our citizens look up to and expect. The Supreme Court is the keeper of the promise of democracy and justice. Every decision made here impacts not just today's Kenya, but the Kenya of generations to come. Today, we are on a journey together. The Supreme Court does not exist in a vacuum. It exists in a society to serve the society. The African proverb, which you all know, reminds us that if you want to go fast, go alone. If you want to go far, go together. Let us be steadfast partners in building a just society, one where the rule of law protects every Kenyan and guarantees their rights and freedoms. As we continue in this partnership or interdependence, let us commit to strengthening our institutions, enhancing the capacity of our staff, and encouraging a renewed spirit of service to wananchi and for the national interest. This is our collective duty. Together, we can realize a more just, prosperous, and equitable Kenya. Thank you. I was told that I will now have the very rare opportunity to invite the Lady Chief Justice to the podium. Thank you.
Your Excellency, Dr. William Ruto, President